It seems like the corruption trial against former President Jacob Zuma faces more hurdles. Zuma insists he will not get a fair trial if he's prosecuted by the state's lead prosecutor, Billy Downer. His many attempts to have Downer recused from the case have failed. He's now seeking to employ private prosecutors to nail Downer over their decade-long impasse. Downer is accused of leaking Zuma's medical records to the media. My colleague Thulasizwe Simelane is at the High Court sitting in Pietermaritzburg ahead of Zuma's appearance tomorrow. He joins us now and will be bringing us more details. Thulas, what can you tell us?
Well, Slindelo, on Tuesday, former President Jacob Zuma will turn 80 years old. If all goes according to the NPA's plan, he will spend that day, which will be the second day of his trial, in terms of it proceeding, because, of course, we are already within trial mode. That actually started when he pleaded not guilty. The trial got underway then. But it doesn't feel like it because, you know, after that not guilty plea and that special plea for the removal of the prosecutor, Billy Downer, nothing has happened in terms of the actual determination of guilt or innocence. There have been what they call interlocutory processes, which had to do with that special plea for the removal of the state prosecutor. So if the NPA has its way, certainly telling us that they are all ready and good to go, on Tuesday he will turn 80, spending the day in the dock, facing those 16 charges that relate to 791 transactions dating back all the way to the 1990s and the arms deal and his relationship with his former financial advisor, Schabir Sheikh. But, as you say, it would seem that, you know, we've been talking about Stalingrad. There was a point, Slindelo, where, one would self-introspect. Am I not exaggerating by saying this is a Stalingrad approach? I think we've since passed that stage where it is clear that there is a Stalingrad approach that is at play here. And what are we talking about? Nothing, not an inch will be given by former President Jacob Zuma's lawyers to the state. The state will have to fight for each and every inch of their case if they are to proceed with this case. And the latest rumblings that we are hearing now certainly signal in that regard. Let me tell you where I'm going to take you in the next few minutes. I'm going to take you through a timeline in a moment of the case. And indeed, I will not go back all the way because that would take the entire hour for us to reflect on everything that has happened. But at the end of the timeline, I'll be in conversation with Mpumelelo Zikalala, who is a legal expert and a legal practitioner here in KwaZulu-Natal, to help us unpack what we've heard, certainly what we've heard from the Jacob Zuma Foundation as of today about their petition to the Supreme Court of Appeal President, Justice Mandisa Maya. So that's at the end of this, but let's start with the timeline. So as I say, we will not start in the 90s. The case itself dates back to 2005 in June, but the latest timeline, let's start it on the 16th of March 2018. That's when Sean Abrams announces that former President Jacob Zuma will be prosecuted on 16 charges after a protracted battle during which he had been battling former President Jacob Zuma, that is, trying to ensure that the case against him doesn't proceed. And indeed, this was after it was found that it was not within Mokotedi Mpshe's authority to make the decision to drop the charges when he did in 2009. On the 20th of May, 2019, former President Jacob Zuma immediately applies for a permanent stay of prosecution, and that is not successful. It is rejected on the 11th of October that same year, the High Court here in Pietermaritzburg dismissing that permanent stay of prosecution application. And then on the 13th of March 2020, he had petitioned the Supreme Court of Appeal to try and appeal against the High Court's decision to reject his permanent stay of prosecution application. That is rejected by the Supreme Court of Appeal on the 13th of March 2020. Last year, we get some movement again, this on the 26th of May, when the trial, as I say, we are already within trial mode. That trial got underway in earnest, technically, in terms of the proceedings of the court on the 26th of May. when Zuma finally, after all of those years, finally enters a not guilty plea. But as things turn out, Stalingrad strategy, that not guilty plea is accompanied by a special plea that says Billy Downer lacks title to prosecute and should be removed as prosecutor in that case. And that goes on, with a lot of back and forth and a number of appearances and arguments. And eventually on the 26th of October last year, the High Court dismisses that special plea. And then he seeks to appeal it to the Supreme Court of Appeal after the judge here, Piet Koen, had refused him leave to appeal to the SCA. Petitions the SCA, and on the 31st of March, the SCA dismisses his petition against that special plea being rejected by this court where we are in Pietermaritzburg. So hopefully without confusing people too much, that really tells us the story so far. Then now, what we've been hearing now ahead of tomorrow's proceedings is from the Jacob Zuma Foundation through its spokesperson, Thulasizwe Simelane. He certainly spoke to the issue of them applying a Stalingrad approach. As I've been saying, they're denying that they're using a Stalingrad tactic. In fact, they are saying that it is the state that is using a Stalingrad approach. Take a listen to what Thulasizwe Simelane said about that Stalingrad approach that says not an inch will be given, each inch of the state's case will be fought over, each stairway, each room will be fought over as the state tries to get this case underway.
We hold the view as a foundation that actually the state is doing Stalingrad. It cannot be that the state is hanging on to one man, the guy who's on retirement is hanging on to one man to prosecute this case. Clearly, there must be so many capable prosecutors here. And we're not hanging on to a man that has got clean record on all counts. It's clean because somebody else says it's clean, but other people, like the foundation, for instance, hold the view that President Zuma's contention that the man's hands are dirty, that contention is correct. I mean, you can go back to spy tapes, era, and all of that. So there's quite a few things. But importantly, the issue here is that we have a man that is soon to be accused, number one, because private prosecution is going to kick in. How is it possible, really, even if you're not a lawyer, tell me, how is it possible for you to be accused, number one, you know this today, that we are going to be accused, number one, in a few days' time. How could you then be expected to run a trial in a free and fair manner? I mean, you're not a robot, you're a human being. You'll be dealing with a person here that wants you to be accused, number one, on a criminal case that carries a hefty jail term, it's like 15 years. It's a serious issue. How can it be that the system just pretends that a person like that, facing such a calamity, will treat you fairly and all of that? It just doesn't make sense.
So that is the latest argument from the Jacob Zuma Foundation, and we expected once this moves from the realm of the, spin doctors to what will happen inside courtroom A here tomorrow, we expect that to be articulated by his legal team to basically say that these proceedings tomorrow should be postponed so that it gives time to the President of the Supreme Court of Appeal to consider their petition for her to, give reconsideration of that decision to deny him leave to appeal, of the court's decision to deny him leave to appeal against that special plea having failed here at the High Court in Pietermaritzburg. But what is the side of the National Prosecuting Authority? Well, the NPA insists that they are ready, that they actually have their witnesses lined up, and basically they are dismissing this latest move by former President Jacob Zuma and his lawyers. Take a listen to what Thulasizwe who speaks on behalf of the NPA, told me a bit earlier on.
As the prosecuting authority, we are ready to proceed with the trial tomorrow when it resumes, and we've always been ready. Our witnesses are lined up to testify against the two accused, and we will oppose any application for a postponement of the matter because it is not in the best interest of anyone for the matter to be delayed further. With regards to the possible private prosecution of Mr. Downer, our lead prosecutor, this we regard as an intimidating and delaying tactic on the part of Mr. Zuma's lawyers, because they know very well that those charges can never be sustained. Hence, the Director of Public Prosecutions in KwaZulu-Natal has declined to prosecute, and the NDPP has refused to accede to their demand of removal of Mr. Downer.
So as far as the NPA is concerned, this is intimidation on the part of former President Jacob Zuma's legal team, and it's a delaying tactic, this whole issue of a private prosecution. So let's unpack two things. Let's unpack firstly the legal basis for former President Jacob Zuma approaching the President of the Supreme Court of Appeal to say that your court has refused to hear my appeal on this matter, but I think you should reconsider that decision. And secondly, the issue of private prosecutions and how it all unfolds. Mpumelelo Zikalala joins me. Once again, thank you for your generosity with your time and your expertise. The immediate thought, Mpumelelo Zikalala, that I had when I heard that former President Jacob Zuma and his lawyers are going to the Judge President, the President of the Supreme Court of Appeal, was to wonder in my untrained mind whether this is in terms of a legal basis, legal foundation. Is it an application, or is this appealing to Justice Mandisamaya's sense of justice and goodwill, I suppose? And I had to turn to you to say, is there a legal basis for this?
Definitely there is. However, the success of it is another maybe realm which we may discuss later. But if you look at the Superior Courts Act, I think it's section 17(2)(f), if I'm not mistaken, it does say whenever a majority decision has been given out by the SCA in which they've dismissed your appeal, you may apply to the Judge President or of the SCA and say to them, these are exceptional circumstances that I'm presenting to you. Can you please reconsider or vary the order that has been received by or has been issued by your court? So basically what the President is doing is within the realm of the law. It's in a procedure that is allowed, or that an avenue that is available to him. In fact, in terms of the timelines, it's still within those particular timelines, because you have to do that within a month of receiving the bad news that your particular appeal will not succeed or not be heard by the SA. So according to the law, yes, he does have that particular opportunity. Coming back to tomorrow's proceedings, it may apply in a sense that he will have to make an application tomorrow here in terms of saying, I'm still waiting for the decision of the President of the SCA. It may come back in my favor, which will have a direct impact and a substantial impact on the proceedings moving on here. Kindly allow for this particular matter to be delayed for a while, up until we've ironed out all those particular issues. And it's up to Judge Cohen to decide, is he going to grant that particular application or not? So
before I get to the talk about the issue of a private prosecution, because that's the other element that now comes into play, Mthunzi Maga confirming that the Director of Public Prosecutions for the province of KwaZulu-Natal is certainly not going to prosecute Billy Downer on those charges that the JG Zuma, the former President Zuma and his legal team had laid against Billy Downer. Before I get to that in a moment, talk to me about how much leeway does Judge Kuhn have around this matter? At what point does he invoke, and I think it was you who pointed it out to me, that there's also authority that says the judge at some point must decide if all of these applications, these postponements and approaching different courts, petitioning that court, raising that matter, raising another matter, is all aimed at abuse of process, and I'm going to put my foot down thus far and no further.
If you look at the Criminal Procedure Act, Section 342(a) speaks about unreasonable delays. And there are a number of points which are then articulated then, which the judge ought to apply his mind to determine whether is this a reasonable delay which we can both endure, or it is something which is a time-wasting exercise and it's not going to get us anywhere. And also look at the precautionary provisions that are there, especially when it comes to illegality and any irregular procedure that may take place. So the judge can say in one end, I'm not hearing your case. We are going to proceed nonetheless, regardless of whether you filed the petition or not. If there are any instances of irregularities after the petition has came back in your favor, come back and file an application according to the Criminal Procedure Act, which will then say, we are registering on record that what you have done, Judge, by allowing us to continue while there's an SCA decision pending or petition pending, it was something which was irregular and not according to law. We want to register this so that when we file our review and appeal proceedings, it is stated on record that you have indeed infringed our rights in terms of Section 35. Now, one would ask, why would you want to overlook all those important provisions and legislation which is there to safeguard so that these procedures are without and beyond any approach? Precisely through what we are going through today, or what is going to happen during the course of next week, of saying there comes a point in which you need to put your foot down as a judge and say, I'm not going to hear any further postponements pertaining to this matter. The reasons, if we were being heard for the very first time, yes, it would have been given an audience, taking into account the circumstances surrounding this particular matter. Yeah. It is not going to make any prudence in order for me to allow you to proceed on your application.
And I do suspect that the former president's legal team will have a great deal of difficulty if they argue along the lines of what Mzwane Lemanyi has been saying, that in supporting their request for a postponement, they will throw in arguments about the suitability of Billy Downer, certainly around the fairness, impartiality, etc. As far as that is concerned, I mean, I think right now this court has made its point about that, as has the Supreme Court of Appeal. I suppose what's new is that whole issue of whether or not anything turns on him, Billy Downer, that is soon to be accused number one in terms of a private prosecution. And that's where I want us to end our conversation. Is it reasonable, Mpumelelo, that a person who may or may not be charged in a private prosecution is basically paralyzed, cannot do anything until such a point where, that private prosecution, as and when it does get underway?
The most important point is that, is there a prosecution which is currently pending against Advocate Billy Downer? If the answer to that question is no, then there's nothing preventing him from prosecuting this particular matter. One may come back on another day after this particular application has been granted, and you ask yourself, what, did you proceed or did you continue with that particular private prosecution? And the answer would be no. What then happens to the resources of the court, to the time that has been lost, to the witnesses that have been lined up that they haven't came in? So it cannot be taken as the sole reason for this particular postponement to be granted. But the court may then say, we want to be fair. Let's give you, former president, the most protection that you may have as per our constitution allows. And we'll grant you this particular application up to a certain point. Certainly by then we do hope that the SCA would have come up with a decision. But let's also remember there's also the concord with that amount of delay. What has been missing in the cases of the former president is the timeless or the without delay filing of certain applications, and so that procedurally they do follow and make sense when you stand up and you're saying you want to fight for the rights of your client. I'll make an example. If this application went about in the following way, you go through the LPC, for example, and say, here's an advocate who has misbehaved. You go to the NPA and you say, here's a prosecutor that has misbehaved, and I want them to be investigated for this particular misbehavior. You then go and open up an SAPS case. And when you argue for that, the no charge to prosecute, you have all those things listed down as part of your affidavit and submissions as to why you want to extend the charge to prosecute even to the conduct of the prosecutor. Maybe it would have maybe a bit swayed the judge. Now one would never know. But when it comes to the procedural, it seems it comes in a staggered approach. One would really want to, is it done purely for the protection of the president's rights, or is it for the other reasons?
Yeah, Stalingrad approach. All right, thank you for that. Mpumelelo Zikalala is a legal practitioner here in KwaZulu-Natal, just weighing in. So what we've heard there, Slindelo, has to do with the legal basis, as Mpumelelo was pointing out, that there is technically a legal basis for the former president petitioning the president of the Supreme Court of Appeal to say, relook at this matter and see if you can vary or clarify the decision of your court and indeed reconsider that particular matter. Whether that weighs in his favor in as far as seeking a postponement here tomorrow before Judge Piet Koen is, of course, an entirely different debate altogether, considering as well that the NPA, for its part, will want to safeguard its independence and basically assert its independence to prosecute without fear, favor or prejudice. Lastly, the political part of things, Lindelo. Let me tell you that in the build-up to tomorrow, the former President Jacob Zuma has been receiving some support. The Musadladla region of the ANC, a lot of activity in the regions across the country indeed for the African National Congress, but also in KwaZulu-Natal, the eThekwini Regional Congress sitting and running into some problems in terms of their procedures, but also the Musadladla region going to visit former President Jacob Zuma. Let's hear now from its regional committee member, Tandanani Vundla, who was part of the delegation that went to see former President Jacob Zuma.
Today is about the comrades of Musadladla region, from Musadladla region, coming to honor former President Jacob Zuma, who is also the former president of the African National Congress. We are honoring him here today in the month of April, which is the month which is identified in South Africa as the Heroes Month. We'll remember that the month of April is also the month where we had our first general election in 1994. And President Zuma's birthday is also on the 12th. So President Zuma, during his tenure of office, he was seen to be one of the individuals who was very much standing with the poor and the marginalized. All the policy positions which were passed during Jacob Zuma's tenure were pro-poor. All operations in terms of economical posture, which was taken during the Jacob Zuma's tenure, was pro-poor. You can remember, Msagas, that very recently we had the High Court, which ruled that triple PFA SCM processes, that one now is not going to be implemented when the government is issuing out tenders or opportunities for small business or business people to do business with government. That is taking us about 14 steps backward, because that particular triple PFA rule in terms of SCM processes was giving the Africans in particular an opportunity to play a role in the economy of this country. Those are one meaningful things which when we see them happening now and we say, no, man, during Jacob Zuma's tenure, such things were not happening.
All right, Thulas, thank you so much.
That's how it's looking on our side, Lindelo.
All right, thank you so much for that, Thulas. Certainly an in-depth look at just what's taken place over the past couple of years.